Final judgment on the Illinois assault weapons ban coming out of Macon County. And we have Viramontes versus Cook County, ND Illinois assault weapons ban, defendants motion for summary judgment. We're going to cover these topics in this video. Please share it, as well as discuss your opinions in the comment section. Help each other out. Starting off with Cook County. Cook County says assault weapons can be banned because more people are afraid of them than handguns. You can't make this stuff up, guys. Beyond the physical dangers, assault weapons also pose greater risks of psychological damage to victims, bystanders, and society as a whole. Public mass shootings are particularly high visibility events that are quite shocking to the public and unsettling to the sense of public safety. The events that lead to significant increases in rate of post-traumatic stress disorder amongst both witnesses and community members who did not witness the event firsthand. One study found that as many as 95% of mass shooting survivors develop PTSD in the aftermath. The possibility of being involved in a mass shooting has become a source of stress and fear in many adults and young people. This generalized fear, in particular, to assault weapons and not handguns, as assault weapons are used in nearly all the highly publicized mass shootings in recent years, including Sandy Hook, Aurora, Colorado, Orlando, Florida, Las Vegas, Nevada, Sutherland Springs, Texas, Parkland, Florida, Buffalo, New York, and in Texas. So for some reason, their ideology is transitioning that the appearance of an assault, so-called assault weapon or rifle, is more menacing and more dangerous than another gun. Cook County also cites research comparing bullets from an AR-15 style rifle, a hunting rifle, a Thompson machine gun, and a pistol were compared, but curiously doesn't say how the AR-15 compared to the hunting rifle. Very interesting, their arguments. Cook County also says that it is not until the mid-20th century that the semi-automatic rifles became widely available. I don't think they have much of a case here. Cook County argues that 223 that is literally impossible to legally use it in self-defense, specifically in Illinois. So this is coming out of Cook County. It appears as that particular case is going well, and as I had mentioned, we have out of Macon County, Illinois, the attorney is confident final judgment in Illinois challenge will apply ultimately statewide. So what we're looking at here is earlier today, an attorney for State Representative Mr. Caulkins out of Decatur said he's confident a final judgment against Illinois new gun ban issued by Macon County Judge Friday earlier today is statewide, pending an expected appeal from the state. Governor J.B. Pritzker enacted the ban on certain semi-automatic weapons and magazines over certain capacities on January 10th of this year. 2 weeks after the ban was in effect, lawsuits were filed in federal and state courts. Macon County Judge Rodney Forbes ruled that the state's gun ban and registry is unconstitutional. Now, this was earlier today. The court is bound to apply the appellate court's holdings to plaintiffs' identical equal protection claim in this case, Forbes said. Now, I had talked about the equal protection clause in a previous video. If you want further info on that, you'll see it here on this channel. The case concluded that Macon County Friday had a temporary restraining order in place barring the state from enforcing the law against named plaintiffs. It is separate from the three other cases brought by an attorney, Thomas DeVore, in Effingham and White counties. I'm sure you remember that cases, which were consolidated by the Illinois Supreme Court. Also have temporary restraining orders in place, but only for the named plaintiffs. We discussed that in a previous video as well. I'm sure you're aware. DeVore's initial Effingham County case secured a temporary restraining order on several procedural issues and on an argument that the law violates equal protection for exempting certain professions in security and law enforcement. The state appealed, and the Fifth Circuit Court of Appeals upheld the temporary restraining order, but only for the equal protection argument. That led to a cascade of 3 other temporary restraining orders to be issued, including for the Macon County case that also dealt with equal protection arguments. Further equal protection and special legislation claims are judged by same standards. So the court is also bound to apply those holdings to plaintiffs' special legislation claims in this case. Forbes ordered, said on Friday, defendants argue that the Effingham County case upheld by the appellate court is wrongfully decided for multiple reasons, but acknowledge that the court is bound to apply it. For these reasons, the court enters a final judgment in favor of our plaintiffs today. Before the order was signed, Stocks explained, he's the attorney, his understanding of its impact. A judgment that a law is unconstitutional, we submit, would be void as if it never existed, and it would be unenforceable in all the application and all respects that it would mean statewide. Stocks told the Center Square the state is not going to concede that point, but the order will have, no doubt, its legal impacts. Stocks said there needs to be a finality to the question so there isn't chaos as an extra around the question of if the law is in effect or not. If the law is unconstitutional, it's unconstitutional, and I would not want to be in a position of any law enforcement ever enforcing a law that has been adjudicated unconstitutional because of their insurance carrier for civil action or depriving of rights and liability. It is going to do handstands and flips, Stocks said. The state needs to move quickly because of that particular question, and we need to get it resolved. So it appears as if we are in the process of winning these battles, but the war is not over yet. We are certainly in an advantageous position, folks, to make this entire thing go away. I would like to thank all the ladies, gentlemen, and entities that have put effortless hours or so much effort into working on our behalf of the Second Amendment here in the state of Illinois. I certainly hope that God's blessing is on them and that ultimately we can just get this thing to go away. Folks, I would really like to know your opinion on this topic. Of course, subscribe to the channel as new updates come about. I'll, of course, be producing videos. I have a lot of other great content on there on what's going on throughout the nation when it comes to gun control bills and overall Second Amendment and preparedness information. I love you. I thank you. I appreciate you very much for tuning in and lending me your ear. Search IPAC Instructor, IPAC Instructor across all social media, and I'll be seeing you soon. Stay safe.